Hello everyone and welcome to the day 2 of the 15th Global IP Convention. Moving on with the first session of the day, let's witness the journey of intellectual property as it takes center stage, transitioning from script to cinematic brilliance. Allow me to introduce our moderator, Dr. Nidhi Buch, Associate Professor of Law, Gujarat National Law University. Dr. Nidhi, a dedicated assistant professor, specializes in jurisdictional issues in the post-trips. Ma'am, I could. Okay, ma'am. Moving on, we have Ms. Persis Hodewala, Managing Partner, JP Legal Corporation. Mr. Jay Vasani, Partner, JP Legal Corporation. Ms. Sweta Merchant Amal Sadewala, Associate Partner, JP Legal Corporation. And Mr. Dhruv Anand, Partner, Anand & Anand.
A very good morning to all of you. Thank you very much for the brief introduction. Sometimes the introductory remarks are a little lengthier, and that generate a lot of expectation in the audience. So I was trying to save all of us so that we'll directly go to the topic that we have to discuss. The topic is very interesting. The phrase which is used for the topic is lights, camera, action. The moment we hear this, there is something which is very creative and entertaining is on its way, is the feeling which is generated. We are not going to discuss how entertaining it is. What we are going to discuss is the journey that it takes from human creativity to the cinematographic excellence as has just been conveyed. So for that, on the panel, I have 4 distinguished speakers with us, and all of them come with the practical experience. And their practical experience will certainly tell us what it takes from in the journey from script to screen. In fact, it's very, probably we have never applied mind to the the titles, the credit that we read at the end of the movie. And most of the time we are doing something else, we are involved, or those days of going to theater, you are very in hurry to leave the cinema hall because there's something to catch at the end. So you don't pay a lot of attention to that, but I think that lamba list definitely tell us that it's something which is very complex, which require lot many people to get involved, and their efforts only can give this shape that we just witnessed. It's a collaborative teamwork, and the complexities added because this collaborative teamwork is ultimately recognized to be individual. And each and every one has contributed with some sort of creativity, and interestingly, we have now an advanced mechanism or a system for protection of rights that can protect each one of them, and their contribution can be distinctly recognized, which is very good because when you are working hard, recognition is something that can definitely keep you motivated for further contributions. So let's try and understand how this journey takes place. And for that, I think I'll first go to Persis because she definitely has that experience, and she can tell us what is this journey all about, what does it take from script to screen. Over to you, Persis.
Hi, good morning everyone. I know it's Monday morning and we are here. Thank you for coming, but such wonderful words. I mean, it makes us proud to be working in this industry, and I've been here since last 17 years. But yeah, today I felt a little encouraged. So today we'll talk about the journey of a script to screen, where what actually goes and how many human hours and what actually happens behind that movie, which a normal public or a person is watching with the popcorn and Pepsi and samosa in the hand. And when people talk good about it, we feel proud. When people just walk away saying, not good, there's always a certain pushback. But that's the part and parcel of life. We've seen successful movies, we've seen the movies go down the tank as well. What do I do on a daily basis is that since now we have our own law firm, in that we get to put our hands down experience wherein we are enriched with knowledge in commercial aspects, as in what goes in structuring the deals. And movie business doesn't come at a very low cost. The cost behind each project ranges from say 10 crores to 300 crores. So what do I do is that whenever somebody comes up to me with a story, we read it, we read the entire script, then we advise our clients that is the market even ready for such kind of a story? What is actually a film or a web series? It's actually a story of someone or a true life event or based on a book. So we read it in depth, then we give the list of the brands to be attached, the list of the electronic items which you will see in the hand or the cards which are attached to it. After that, we get into negotiations and we start finding out that who will be the actors on board and who will be the captain of the ship, which is our favorite person, is the director. Legally what we do is that we make sure that all the IP is parked with the studio. Everything gets assigned to the studio. Nothing remains with the talent. When I say that, it means that the entire IP is sitting in one production company, because there is a future to that. Every penny which is invested has to be recouped. Jay will talk more about that. I don't want to touch upon that. But legally we make sure that the chain of title involved in the writer agreement, in the story, even if it's a biopic or it's a book, everything is clear. And if it is not clear, then we jump into it and we start preparing our paperwork for that. We also enter upon writer agreements, because the writer is whatever the writer is writing, it is in a form of literary work that we get it assigned. Then when they go on shoot, it is a form of an audiovisual work. Then there is music, there is dance, there's makeup, there's hairstylist, there's poster, there's printing. Each day of the work towards a particular film creates IP. We are invested in one movie for 18 months of our life, and we churn out almost 150 to 200 agreements in a span of say 6 months. There's a timeline attached to it, and we function in hours and we function in terms of days, because the shooting days are allocated. We know so our work is backtracked. We need to start beforehand, before everything, before the shoot day, before the first shoot day. The entire pre-production work has to be completed. That also includes agreements. Because as per the latest rules of the platforms, when I say platforms means Netflix, Amazon, Jio, Hotstar, their primary rule is that all the agreements needs to be in place before the person faces the camera. So we also, when we do the window agreements means when the rights are sold to the platform, we have to abide by their annexures, which runs into 20-25 pages. So every day we are reading, then we are making changes, and also we have to customize. Every director is not the same, every producer is not the same. We need to customize the whole structure. Also, there are huge numbers attached to it, because we are in the industry since a very long time. We know what numbers to be allocated to every aspect, while there is a cost invested towards the film. Each shooting day at times ranges from 50 lakhs to 1 crore to 4 crores each day. And there are 300 people working on that particular set, including their safety. Then that pushes me towards insurance. We cannot start a shoot if there is no insurance. Even the actors needs to be insured. Every person on the set also, we make sure there's safety for them to come to work the next day. So there are different aspects attached to it. Also, there are locations. Before the shoot happens, we need to make sure that the locations, what the director has in mind, is it even viable to shoot? What about the climatic changes? What about natural calamities? Is the actor ready to go to that place to shoot? What about the safety? If it is shot in jungle, what about the permissions? If it is shot on airport, railway station, roads, even when we shoot in Delhi here, there are tons of permissions to be taken here. Yeah. So the production team comes here 1 month, 1.5 months before, applies for all the paperwork, and then only you can go on board. So as a lawyer, we are involved every day, and we also get calls in the middle of the night that if I have shot something on the screen, do I have rights for that? Can I show a match on the television screen? Can I play a song on the radio while the actor is driving a car? The answer is no, unless you have taken the license. Is it easy to take the licenses from the respective copyright holder? it is difficult. Like when we show news channel on the TV, we need to go to Aaj Tak. We need to knock on their doors that please allow us permission to use the footage for say 50 seconds, 45 seconds. We also have to check that that footage playing on the TV is not demeaning or not in any manner walking upon somebody else's IP where the actually camera is roaming around. So there are like minute things we need to make sure. Are there any paintings on the wall? Even when I did, I can give you a live example. When I did Sacred Games on Netflix, when I was at Reliance, Netflix had a great trust in my work, and we started Sacred Games. The laundry list which they sent to me to make sure that I don't touch anybody's IP was enormous. And I, as a person, had to go through the rigorous training from LA to make sure that we are not infringing anybody's rights. And the first thing they told me that if there is a painting on the wall, when the camera is roaming around in that indoor shoot, please take permission from that. So what did I tell my production team? Please don't put any paintings. Please, I don't have so much of time to go to the painter and take any NOCs. But there is a scene, I don't know how many of you all have watched Sacred Games. There is a scene in which Saif enters the room, and there are photographs of the models kept on the room because there's a murder happening there. There are models, there are photos of that models. You won't believe, I had to take an NOC, one-pager NOC, from all the models whose photographs were stuck on the wall. Imagine my tedious work. I'm leaving everything behind. I'm leaving Saif's agreement, and I'm looking after this NOC. But these managers are also very, sometimes they're difficult, but sometimes they're very helpful. Obviously, because they also want the agreements to be closed in time. The actor agreement, Shweta will be talking in depth about it, but the actor agreement at times runs into 8 pages, depending who the actor is, to 28 pages. Because the actor also has to be complied with all the regulations laid down by the producer, studio, platform, whatever we may call it. And what about the brands? Today, every actor, even the director wants to be associated with the brand. Can we walk upon the non-compete brands? No. So first we call the manager in the room. Then we ask, please give us a list of the brands which they are representing. Actors represent multiple brands. So there is no crossover. There is a clause in the agreement which runs almost into 2 pages where we say that we'll not touch upon that. Then there is active branding, passive branding. And when we go to the brands, if we go at a pre-production stage, they will give us in-film branding. But if we use their brand or logo without checking with them, and if they come to know, then there is a lawsuit on us. So as a lawyer, as a commercial person, or sometimes we say that, filmmaking is a process. But if there is any slip out from a lawyer's standpoint, it costs a huge amount to the producer. And that is not right. Even if you have to push that extra mile to do something, even when we get involved in marketing, what does a lawyer have to do regarding the marketing of a film? Because we give credits. We tell them, okay, you'll get credit on this. Why are we working with this? Passion is for credits, of course. Money comes later to us, much later in life. But we only work for credits. As ma'am said, that the credit scroll. Yes, as a child, I always wanted to have that name in the credit scroll, which I've fulfilled after many years of studying and hard work. But yeah, the credit when our name goes, that is the proud feeling. And even as I said about the brands and the effort which goes, even when we give credits, even on a poster, we have to make sure that whatever is mentioned in the agreement, the credits are accorded according to that, to the respective person, because there are many people involved in it. So we're not only legally involved, because this is a very vulnerable sector of life. It's not structured, like you don't have there's no process as such that, okay, you have this format. No, we have to make we have to sit down and make formats, because they're all creative people. When I tell my producers at times that, let's not get into this, let's not make this, but that no has to be backed up with a lot of reasoning, we don't have, as lawyers we don't have case studies. We don't have past judgments. We cannot tell a creative person that, okay, in that judgment, no, we can't. We need to back it up with a lot of market study, with the numbers, with the percentages. with the target audience. Target audience means that if you're making something, is the audience, as I said, is the audience even ready for it? What is your target audience? At what age group do you want to showcase this kind of a content? And if that is the target audience, if that is a particular cast, if you're showing, do they have that much revenue or money in their pocket to come to the theater to watch a film? Because in no time it is available on OTT now. So yeah, that's the holistic approach. Obviously, we try to keep our agreements short. We try to make sure that we've taken all the IP, all the rights, music, dance, makeup, hairstylists, actors, writers, directors, even the caterer who comes and serves food on the set. We do an invoicing and we make sure that everything is assigned to the studio. So everything is parked at one end. I don't believe, and I never advise my clients to split the IP in 50-50. Because God forbid in life, if you don't want to see that person's face, your lifelong you're stuck there. Then what happens about the derivative rights? What happens about merchandising? What happens to NFT? Today NFT is the talk of the town. Today actors want to retain the NFT because they want to exploit that character into gaming, into merchandising. But me, if I'm on board with that project, the NFT comes to the producer. Because the actor is not got involved to create that NFT. It is the studio, it is us who are giving you that platform to be that particular character. I don't even want to get into the nitty-gritties of what movies I've done in my life and what movies are coming up. But we make sure that that NFT is in place because tomorrow definitely I'm going to exploit that movie on Metaverse. The process for us has already begun. We already have cinemas established on Metaverse. We already have gaming coming in place. We also have merchandising. So I will never let the actor retain the revenues what we earn. Of course, if it's a great rapport with the actor, then we request them to keep a percentage of that revenue, but the IP still remains with the producer. So imagine our transition. I have been involved in the film business, I can say, when we used to have actual reels, which used to go to the theaters, and then that person used to upload it. Till now, till the digital, so we have a DCP, which is digital cinema print. So I have been very lucky to be a part of the industry, and I have seen the industry transforming from the print to the DCP. I also have a lot of hands-on experience in the digital aspect. Nobody ever wonders, that when we go to the theater and how is the movie getting showcased on the screen. Nobody even thinks, because obviously people, for a normal person to go to the theater, it is like, it's an outing. But for us, even that is a study. Hope there is no piracy. Hope everything is reaching on time. I hope there are passwords, reached to that server to start showcasing the movie on time, because there are slots allocated. Like morning 5 o'clock, the show starts sometimes. Hope the password has already reached. And that whole distribution aspect is completed so that the normal public can go to the theater and watch movies. And now I think I can go on, but now I'll hand it over to, yes.
Yeah, thank you very much. You've really tried to summarize the journey. I think with which all of us definitely are well now aware of the fact that it's not about performance. Otherwise, movies are synonymous to performance. But in order to make that performance reach us, there's a lot that is required to be done. Now, with that, I think I'll go to Shweta and request her to throw some light on what type of, because in order to create right, there's a mechanism. So either the law would create right, or through law you create right. So I think contract is a tool that creates rights and liability. In case of IP, it's rather one has to be more careful that rather than acquiring right, you have to be more guarded that you don't end up infringing somebody else's right. So how that thing is actually converted into a reality, for that Shweta, please. Thank you.
Good morning, everybody. First of all, a very happy new year to each and every one of you. I know it's a cold winter morning, but I'm sure we are all ready to listen to what we have to say. So yeah, when a film production starts, we do not sit and do agreements with each and every person who is working on a film. There are approx 200-300 people who are working on a film or an OTT series. So we execute agreements for people who are actually generating the IP. It's not for every person out there. There are a lot of nuances involved. Every agreement is different, every negotiation is different. So yeah, I'm going to speak about, let's say for an example, an actor agreement. Essentially, there's the naming clause, then there's the recital clause. The main contract starts from the principal understanding. What kind of services are we expecting from the actor? What kind of work he's going to put in, his role? That is what forms the part of the obligations and the principal understanding. We have the definition clause, which has important definitions as to the pre-production schedule. He has to prep for a particular role, his body, or the kind of hours he has to put in for a pre-production schedule. Then we of course have the shooting schedule. He has to give the number of days when he'll be available, whether those days are going to be consecutive, non-consecutive dates. That is decided of course between the parties. Then we have the promotional period, which is very important. Every actor who is working on a film wants to be a part of the promotion series, so that is also decided. The X number of hours or the days that that person is going to give in the promotion schedule. Then comes one of the most important clauses, which is the ownership of the IP. The person we are hiring is a work made for hire, so whatever IP he's generating has to be assigned to the production house or the studio for that matter. He cannot retain any right with himself. So then there are various sections of the Copyright Act. Ma'am is essentially aware of those, like the 19A or the 19.4, performer's right under section 38. Everything has to be assigned to the studio, so that further when somebody is doing a sequel or any derivative work of the film or the series, they have all the rights retained with themselves. This is essentially what is happening in the present, but of course we have to secure the studio for the future. There are new exploitation rights, as Persis said. There is metaverse, there is NFT. We don't know what else is going to come up in the future, so we ask the actor to assign all the rights for the future exploitation methods as well. Then comes the consideration clause, whatever has been decided between the parties. Mostly the first tranche is on the signing of the agreement, and then the last tranche is retained till the end of the promotional period or a week before the release of the audiovisual content. Then the most negotiated clause that comes in is the credit clause. Like Persis said, everybody working on the film wants to be seen on that 70mm screen. Where is my name showing? So these actors, they have this very specific requirement when it comes to credits. Some want top billing credits, then there are single slate credits, then there are shared credits, of course. But it is one of the most heavily negotiated clause in the agreement. Then, of course, we come to the other clauses, like the branding clause. Like Persis said, there is active branding, there is passive branding. An actor should not be seen holding a brand which is a competing brand. So suppose a particular actor is endorsing, say, like a Pepsi, he cannot be seen holding a Coca-Cola. So like she said, when we start to negotiate and sit for the agreement, we ask them for the list of the brands, what brands a particular actor is promoting, and we ensure that there is nothing which infringes his agreement or his contracts with the other brands. Then we have the termination clause. That's the favorite of all the lawyers. We ensure that there is no termination of the agreement. We never want that. No actor wants to step out of a movie or be pushed out of a movie for no reason. But yeah, there is a termination clause to protect the rights of the parties. There are two kinds of consequences when it comes to termination. So yes, when the agreement is terminated by a studio, for the breach by an actor, suppose he refuses to shoot, or he refuses for any XYZ reason, or he does something which can bring disrepute to the studio or stall the shooting, then we can say that, look, whatever services that you've provided to us will be retained by us, and the payments that have been made to you are full and final. We'll not be making any further payments, even though as per the payment tranches, he is entitled to further payments. When, God forbid that never happens, but if a studio is not able to make payments, then of course we pay the pro rata payment to the actors or the talent who is providing services. Yeah, that's about it. And I think the remedies clause is another thing where we ensure that the actor can never go to court, or there is no situation where he can go and stall the release of the film or the shooting of the film. The maximum thing that an actor can do for breach by the studio is to seek damages in the court of law, which ideally does not happen a lot, but yeah, that's something which they need to protect their right. So these are the important clauses in a drafting, but yes, like I said, every agreement is different, every actor is different, their requirements are different, so we have to work differently. It's not like we follow a standard template and then it goes on. So thank you.
Thank you so much, Shweta. She's almost given a blueprint of an agreement. And as she said, it's like it seemed to be very simple and easy when you just look at those clauses. But then the detail of the clause is very subjective, and it depends on whom you are entering into the agreement with, what rights you created, what liabilities for the third party are being created. And the thing is that it's very, very challenging for the one who's putting all these things into words and penning down it, because one, as Persis rightly pointed out, one small the point being missed out will create huge sort of liability for the producer, and that will definitely hamper your practice, which is a byproduct by all means. So thank you so much, Shweta. With that, I think I'm ready to go to Jay, who will talk about the legal framework, variety of rights which are being created. We are talking about it, but how those rights are being created in the domain of IP, and especially copyright. But yes, contract is something which is inevitably part of filmmaking, with which the rights and liabilities are created. So, and something more that you can add from your experience, please.
Hi. Good morning, everyone. So, like Persis and Shweta has already touched upon the nuances and everything, but mainly the agreement is for the commercial aspect of what a studio is going to pay out, right? Or the studio is going to get from the production of the movie. The main base is that. So there are like hundreds of things, but the main important thing for any copyright that is being generated is how can you commercially exploit it. If there's no commercial exploitation of it, I don't think there is any use of the retaining the IP or creating any sort of IP. So anything that goes on the set, for everything there is a payout that a studio is making to get back returns. So there's a huge waterfall clause for it, where the production houses are investing, supposing X amount. So there will be a cost of money to it. Then there are exploitations, non-theatrical, theatrical. So non-theatrical is your satellite, your OTTs, your music, your gaming, your merchandising, and now NFTs and metaverse have come in as an additional source of revenue for the production houses. So the waterfall, okay. So theatrical is the most important aspect for a movie, because that is where the most of the revenues is going to be generated from. Second is the non-theatrical. Non-theatrical has your satellites, your channels, your Star, your Woot, your everything, your OTTs, your Disney, Hotstar. And then comes gaming, but that is on the later part of it, if it ever happens. So satellite
revenues are maximum, and what Jay means to say from the waterfall clause is that when every rupee is being expended over a period of 12 months towards the COP, that has to be recouped in the form of obviously that has to be recouped in some form. We call it a waterfall. Is that what is the first window from which the money is coming in? It's a theatrical window. Obviously everybody goes to the theatre. Whether that film is a feature film or it's direct on OTT, these are the two aspects. Second window, we make sure that the distribution commission is in place. Then the marketing and P&A, whatever is expended by the studio, the percentage of that is also recouped. And whatever is the remaining after that is the profit. But by the time the profit comes to the studio, it's almost 2.5 years. But the maximum revenue generated for us is through films. So first question we ask the producer is that, is it a feature film? Is it a direct to the platform, or it's a web series? Sometimes even while we are making the film, we think that let's not take it direct to the theatre, because we know the market of late, because thankfully after Jawan, Pathan, Animal, and RRR, the theatres have come back in life post-COVID. But we make sure that, so first question is whether is this applicable? Because if it's a feature film, then we have to go through the Cinematograph Act, we have to go through the CVFC provisions, we also have to edit the film as per the theatrical window. But if it's an OTT, then we can take a little more creative leverage and showcase the content. And the last is the satellite window, because whatever you see on the OTT, again INB keeps changing. INB is Information and Broadcasting, they keep changing the laws. So we have to make the material ready as per the satellite window, because satellite has no control. It's open to everybody. And then when we sell rights under the satellite layer, there are more than 20-25 rights. There is, you can watch on Tata Sky when you want it, you can download it, you can watch it with ads, you can watch without ads. You also watch it in the flight, you watch it in the hotel. How does this kind of content reach all these platforms? Basically, even the tier 3 needs to have the access to the content. So we make sure that all the rights are in place and none of the rights are overlapping. Because from the theatrical window to OTT, it's 90 days. No, sorry, it's 60 days. And then from OTT to satellite, it's 60 days. So none of the rights are overlapping. Like free TV is the maximum which the platforms wants to keep, but it cannot overlap. And it's not that they are exploiting only in India. We exploit movies across the world. Even when we release our web series, they get dubbed and subtitled into 135 languages. And it is just like India today has, as we speak, India today has 5,600 screens, theatrical screens. Only India. So imagine each form of that film reaching these screens on time, and it has to be distributed worldwide. When it is distributed worldwide, we divide the territories into Middle East, US and UK, because Middle East has a stringent laws to exploit content. UK is quite open, and then again when we reach US, the laws are different. So we have to touch upon everything, but we need to make sure that if we have invested, or if our client has invested 100 rupees in a certain project, we are recouping minimum 200. Otherwise, there's loss is not what we and as lawyers, if we see the loss on day one, how do we forecast if it's a loss? By reading the script. After reading the script, when we study the market, and if we see the loss on paper, we advise our clients immediately not to go ahead. Because even after selling the final music rights, we are only allowed to sell our songs. We are not allowed to sell our BGM. BGM means background music. Background music still gets retained with the producer, but the songs are assigned to the music label. Even after selling that, merchandising, gaming, NFT, if there is no revenue left in the kitty, then we make sure that we tell the producer that it's a big no. So we have a say in the matter as well. Yeah.
Thank you so much for extending that part, Persis. I think before I go to Dhruv, because Dhruv will be talking about the litigation, because he's the one who will be talking about how these rights actually, when infringed or when they are required to be realized or re-established, what is to be done. But I think before that, let me just very quickly and briefly touch upon how these rights are created under the law. Apart from contract, as we know, the copyright legislation, which create all different kind of rights, starting from literary, artistic, dramatic, musical, cinematograph, film and sound recording. So, and also there's a separate clause for performance right. All these things are part and parcel of copyright, and interestingly across the world, thanks to the Berne Convention before years together, the copyright acquisition is almost automatic. Though registration isn't automatic, but once the work is created and published, put it in public access channel, it is something which is protected. So that is something which makes protection of it more tricky rather, because in case of patent it doesn't happen because you get right only on registration, whereas here registration isn't required. However, in absence of registration, there has to be something tangible that can speak loudly and clearly about your rights. So that is where the contract comes in picture, and with all these care being taken when the rights are infringed or violated, how that is being contested in the court of law. So for that I'll go to through Dhruv, and I'll also request him to talk a bit about performers' right and his experience with music industry.
Hello everyone. A very happy new year to everybody. So I think Persis, Shweta and Jay gave us a very nuanced and intricate understanding of how filmmaking, what all it entails, right? There are a lot of permits, a lot of releases that have to be secured, and the ultimate objective of that is that there are no impediments when it comes to screening the film or exhibiting the film. And that's what the business is for, right? The idea is disseminating the film without actually getting lawyers involved and the litigation hampering any aspect of that. But fortunately, unfortunately, things happen, and there are disputes that come to court. Just one thing, and in fact, Dr. Nidhi just mentioned that, and I just thought I'll highlight that before I just get into the other aspects, is that copyright, it's called the Cinderella of intellectual property, and for a reason. It's got many advantages, and one of the most obvious advantages is that the moment you put pen down to paper, right, you may have copyright in whatever you create, as long as you pass the basic threshold of originality and creativity. And so it's so easy for any work to be the subject matter of copyright. And India's a member of the Berne Convention, which means, and because of certain principles of like national treatment, etc., your work created in India is protected in all those Berne countries, instantaneously. And that is not seen with any other forms of intellectual property. One. Two, you don't have a formal system of registration. In other words, you don't need to register a copyright work for it to be enforced. And that's also another huge advantage. Having said that, obviously because the ease of which so many works are created, which are all elements of human expression, because of that, there's various overlaps of copyright. And you see that in films, you see that in music, because the same set of rights are often given to different individuals, and that overlap causes a lot of disagreements and litigation. I just thought I'll highlight that before I get into the other aspects. I think the first thing I can possibly speak about, perhaps because that's quite interesting, is the journey of how music has evolved, right? And music is such an integral part of films, and I think it all really begins in 1977 when there was a Supreme Court judgment. And pardon me, I'm a litigator, so a lot of what I say is going to be kind of court-centric and from the act itself and the legislation, because they have such wonderful industry knowledge. I'm just going to try and complement that by telling you the legal position. So 1977 is when the Supreme Court decision in IPRS versus EIMPL happened, and that was a case in which IPRS had come up with a tariff. It was a collecting society for authors of underlying works, literary and musical works, and they came up with a tariff which was published in the Gazette. And the producers of the cinematographic film said, they actually objected to say that, look, all the rights that we commission, right, from the owners, the authors of the underlying works, they all get subsumed in the film, and we therefore own the entirety of those rights, and therefore no additional permission is needed from the collecting society if that music has to be exploited, if that literary work or music has to be exploited. That was the dispute. It went all the way to the Supreme Court, and the Supreme Court essentially said that yes, as far as cinematographic films are concerned, those are works, a lot of the works are works made for hire, and those are commissioned, and by virtue of the deeming provisions of law, the producer owns everything, right? Now, obviously I'm not getting into the provisions and the nitty-gritties of it. There was a lot of criticism, because basically what that meant was that you're depriving authors of underlying works with some of their valuable rights, right? In other words, there was a system by which they used to be paid an upfront, lump sum fee, and let's say 50,000 rupees for a song, and the song would go ahead and become a very big hit. So the payment was not commensurate to how the song was actually going ahead and becoming a hit. So it was thought that it was unfair for the longest time, and obviously because of the bargaining power that the producers yielded, these authors for a long time could not do anything. Then after that, there was a series of litigations in 2012, which was another, in fact, I'm sorry, I'll go back. In 1994 is when the performers' rights were introduced in India. And I'm just going to come back to that, circle back to that, but because that's very important in the context of music in films. But after that, there was a Aditya Pandey case, which again went up to the Supreme Court, and that also, in a way, kind of agreed with what was said in 1977. So after all of that, eventually in 2012, there was a major amendment to the Copyright Act. And if you see the statements of objects and reasons and the whole parliamentary committee report, they actually said that this situation needs to change because the bargaining power between producers and authors is so skewed that these authors need to be remunerated and paid some royalty every time their work is used and commercially exploited, right? In other words, just because it's included in a cinematographic film, the right should not be subsumed and defeated. So that provision for streaming royalty came in 2012, and there were various amendments in the Act. And so 2012 was seen, as a watershed moment for performers, because and now, of course, I'm going to get into what performers means, because performers includes singers, not only singers, but even actors, right? And a film may have many, many, many performers. And the question is, how do you protect those? Now, performers, as I said, is defined. Performance. Performers only applies to a performance. A performance is also defined as any, a presentation, an oral or a presentation made live. Now, the question is, what is live? And this came up for interpretation in a big litigation that we were fighting for in the Delhi High Court for ISRA, which is the Indian Singers' Rights Association. And the singers, the production, the sound recording companies, they said that, look, performers' rights will only attach to live. It says live. So live means it has to be before an audience. It can't be that you go to a recording studio and sing and you get performers' rights. We argued to the contrary, because we said that in if you see the Act, what live really means is in flesh and blood. In other words, every performance is live in the first instance. It has to be. Because otherwise, whatever you're shooting in a film before a camera, nothing is live. That means no performance rights will be attached. So that will be an absurd result, right? And so we argued to the contrary. Ultimately, what happened is there was a big settlement that was reached between the producers and the singers. And happy to say that the singers are getting their due now. That was, we like to believe, a result of the litigation also, at least a part of it. But as far as performers' rights is concerned, what are the other ways in which performers can protect themselves? And that's the question. Now, there's one of the provisions in the Act that lays down various exclusive rights that a performer has. For instance, a performer has the right to a fixed performance of his being recorded, right, or broadcast or communicated to the public, or him issuing copies of a performance to the public. Now, these set of rights are almost akin to copyright. So in a film scenario, a producer will obviously have to acquire these performers' rights, right, by way of an assignment, so that the performer doesn't later claim that, look, I have any, right left with me. But one thing that the performer cannot assign away is the right to receive royalty, because that is an inalienable right. And if you see section 38, the subsection 2, because subsection 1 has a set of rights that you can assign and part away with. subsection 2 and its proviso says that if the performer agrees to the incorporation of his performance in a film, he can't object to the showing of the film in a cinema hall. Yes, he can't. Subject to that, so long as he receives a royalty. So that royalty provision is very important. And obviously the object of the law is clear that they want to bar, because of the bargaining power, they want to bar any assignments to the contrary. And so that has kept performers very secure. In practice, I believe, and I might stand corrected, but I believe that it doesn't play out that way because the performer says that you will not in any way claim royalty because, you've already received a certain consideration.
To add to Dhruv, I make sure in all my actor agreements they say we will not claim any royalty. The only thing you can retain is the moral rights.
Right.
Because royalty, if the actor starts demanding, then there is, as I explained, the waterfall.
Yeah.
There will be no money in the pot for the producer. But yeah, for musicians, on the contrary, we tell the musicians, because of that settlement, we tell the musicians that, okay, whatever money will be made, some portion of the royalty will get accrued. That came, I think, because from LA it's come, because there it is very structured,
Right.
like with SAG and DGA. But here, I think, I don't know if, do they have these musicians, do they have a set label or somewhere it is mentioned that if the song is earned so much of revenue, they need to get, a portion of that. I've never come across that schedule here.
It's not that streamlined in
okay, yeah,
India, although there are collecting societies that have tariffs.
Yeah.
Right? And so the payments are made according to those tariffs.
Okay.
And of course, there is a provision by which call sheets are actually shared. So
Correct.
that will enable you to know where music is played, how much is it played, etc., etc. And based on that, calculations are made. But it's not as
It's not as
streamlined like in
structured
America
as there.
and other
Yeah,
places.
yeah. But not in my actor, director, writer.
Yeah.
We just say, the managers push back, that please give us royalties.
Yeah.
Our answer is flat no.
Correct.
And then they compare themselves to the musicians.
Yeah.
But music is separate and this is separate for us. Yeah.
Yeah, absolutely. So I was just on performers' rights. Those are some of the issues. Now, how do you protect performers? Additionally, you could protect them. There are issues of publicity rights, and we've seen that a lot. Recently, we all read about Anil Kapoor enforcing his publicity rights and personality rights, and that's a big problem now because with the advent of deepfakes and artificial intelligence and generative AI tools, a lot of the actors' personas and attributes of his persona are being misused without their permission. And that's a problem, obviously, because especially in a situation where the actor's, let's say his face or his likeness or his voice is being used to sell a product or a service. That obviously is not done. If it's being done for, let's say, informational purposes or something which is newsworthy, still understandable, right? But if it's been done in the deepfake scenario where, let's say, it's used for pornography, then there's a complete no-no. So obviously, the dangers are, myriad. There are many, many dangers. How do you regulate those deepfakes is a question, like they're doing in certain parts of the US. And I think there's a need to do that in India as well for deepfakes. But the right of publicity is one tort that performers can use to ensure that their persona or any attribute of their persona is not in any way misused. Now, publicity rights is quite flexible because it doesn't just mean the image of a personality or his, or his picture. It could even mean his signature, any attribute. So it could be his voice, right? Even voice advertisements where singers with similar voices have also been stopped, right? Yes. So publicity rights is something that performers can apart from, in conjunction with copyright, use to stop their persona from being misappropriated.
Sorry, but I've been told by the organizer that we are running short of time, so I had to cut you in between. Thank you very much for throwing light on the performer's right also. The concept of celebrity right or personality right is new to India, and we have yet not recognized it completely. We are not quite, because that is not just in the film industry, that's quite prevalent in the sports industry also. And we probably, as we get those kind of awareness among those who are performers or sports person themselves, celebrity right, personality right, all these things definitely will also be part and parcel of performers right. So I think thank you very much. We have discussed almost everything, starting from how the rights are created to how the rights can be put in tangible form, and how the rights once violated can be litigated before the court of law. I'll ask if we have time for questions.
Maybe one or two.
Yeah. Maybe one or two questions.
Yes.
Okay. So maybe one question we can take.
Yes.
During the break,
Yeah, just
so there was a topic on the royalty, right?
Yeah, we can hear you.
So the royalty for the music can be given, but not for the performer, right? The royalty for the musician, the music can be given, right? So who is it lies with, the musician or the music company? Who will be holding the royalty for that, like the right to loyalty?
Yeah, so performer includes an actor and a singer, right?
Yeah.
Now, because there's a collecting society for singers, they've actually asserted the right to collect royalties whenever their music is utilized, right? Like that, actors can also have a collecting society, right? Although I must say that there is also a provision in the Act that says that somebody's performance which is merely casual or incidental, or whose names don't appear in the credits of the film, is not considered a performer. But, and that takes out, a lot of the ancillary performers. But actors are definitely performers, and if they have collecting societies, they too, under law, could claim a right to receive royalty. But for that, they need a mechanism of a collecting society. And yeah, that's
Thank you.
thank you very much. I think this brings us to an end of the session, which definitely can go on for hours together, because of the very nature of the rights which are generated and created and are required to be protected. Thank you very much for making it very live and interesting with all your experience. Thank you very much.
Great thanks to our speakers. Now I'd like to welcome Dr. Dhanpatram Agarwal to give out the gifts.